Yes, Mr. Rowe.
Yes, may it please your lordships, in this case I appear for both appellants, together with Mr. Royston, Mr. Hutcheon and Rosalind Bergin. Learned friends Edward Brown, King's Counsel, and Talia Zibuts appear for the Secretary of State. I don't think there's any real housekeeping. There are 3 bundles, a core bundle, a supplementary bundle, and a bundle of authorities. And I've handed in one loose authority, which we may or may not come to, but to do with parliamentary materials.
Yes, thank you.
We'll see when we get to one. The lordships will have seen that this is an appeal against the decision of the Upper Tribunal, which dismissed the 2 applications for judicial review of the Secretary of State's approach to the allocation of national insurance numbers and its relationship to payments on account of or of universal credit. Permission to appeal was granted by Lord Justice Lewis on all 3 grounds, or our grounds, on the 5th of December last year. And as we recite in the opening of our skeleton argument, the factual position is that the respondent makes payments of universal credit and advance payments on account of universal credit only to people who have a national insurance number. It's now clear that this is because the Secretary of State's view of the law is that he cannot do otherwise. He argues that the construction of the advance payment regulations, which we advance, is incorrect, and that the Upper Tribunal was correct to say in paragraph 59 of its substantive decision that it could never be said that the condition contained in section 1, subsection 1, large b of the Social Security Administration Act was likely to be satisfied before the information provided by the claimant in relation to his application for national insurance number was verified, and also that the construction advanced by us of section 1, subsection 1, large b was also wrong. We dispute both those contentions. Importantly, given the way some of the respondent puts his case in some of the skeleton argument, we disputed both those contentions before the Upper Tribunal. And I will take your lordships as quickly as I can, in due course, to the pleadings to make good that proposition. So the grounds we advance are shortly summarised, so we know where we're going, in paragraph 4 of the skeleton, of our skeleton.
Yes. You don't no need to read them out unless you want to make some point about them. Are you going to take them in this order? Speaking for myself, actually I know, speaking for all 3 of us, we think the more natural course is to take round 2 first. But if you particularly want to take round 1 first, we won't actually stop you.
Having said I'm in your lordship's hands, I therefore have to take round 1 first, I think.
Well, I know if you've prepared something a particular way, it is, even someone of your experience, Mr. Drabble, it can be tiresome to have to do it another way, so I meant it when I said if you want to do it that way.
Well, my hesitation is that it may be helpful to understand both grounds if your lordships fully understand. I'm sure your lordships have read in to the extent of understanding to a considerable extent the way in which the system is actually operated by the Secretary of State, because it's important to see the 2 stages which we've described in the skeleton and which Mr. Brown describes in his skeleton actually in operation, in order so that we can see what's been...
I couldn't agree more about that. I did, but at the moment I don't see why that means you need to take round 1 first. But look, let's not do it the way you want.
Well, it would go with the way I prepared it.
Well, that's good enough.
If I could say this, if I can deal with the statutory scheme and the way in which the scheme is actually operated before coming to the 2 grounds. Now, I don't then mind very much at all which way around the
that's fine. That's fine, certainly. Okay.
So that we take
of course. Well, I'm all for that.
Spend more time on it. We take ground 1 when I come to it first, but in the context of having seen how the scheme actually operates. It's operated. Now, yes. Your Lordships, I mean, your Lordships have seen the various grounds. Your Lordships will also have seen that at page 91 of the bundle, the three grounds are, of the core bundle, the three grounds are set out. So, my note says I propose to proceed by saying a word about the facts of the individual cases, showing your Lordships the statutory scheme both as to the provisions of the primary legislation in relation to the need for a national insurance number and the making of advance payments, and a word about the evolution of the scheme. Thirdly, a way in which we put the case to the Upper Tribunal, taking from the statement of facts and grounds and reply before the Upper Tribunal. Thinking about that in the light of the exchange we've just had, it may be that I put that to one side until we see whether it's truly necessary or what's in play. Fourthly, a summary of the way the Secretary of State operates the scheme, and then fifthly, submissions on the individual grounds. Your Lordships will have seen there's an issue about parliamentary materials, both in relation to the advance payments issue and in relation to the...
Well, again, the strong provisional view we formed is that we ought to allow the point to be developed, de bene esse.
Yes.
It's really difficult to see, to form a view as to whether it's helpful or not until we've heard the argument and heard it in context. So unless Mr. Brown radically disagrees, that's how we're going to do it. Okay.
I don't know whether your Lordship have got to the stage of seeing that there's a Pepper and Hart issue in relation to the first ground and a objective setting issue, if I could use that shorthand, in relation to the role that was envisaged for advance payments at the time that the section 1 large B was enacted. But they're both contained within, I think, a single column, the principal material at least, within a single column of the Hansard relating to committee proceedings. So the facts of the individual cases, I can ask your Lordships to glance at our skeleton, core bundle page 33, just paragraphs 10 and 11. So paragraphs 10 and 11, page 33. Appellants are both foreign nationals who were ultimately accepted to meet all of the eligibility criteria for entitlement to universal credit, which who applied for universal credit at a time when they did not have a national insurance number. Ms Bui claimed universal credit on the 13th of January 2021 and was not paid anything until the 26th of May 2021. Ms Onakoya claimed universal credit on the 8th of April 21 and was not paid anything until the 11th of June 2021. Both were experiencing serious hardship throughout, living in temporary accommodation with their young children. And the delays in the payment of universal credit to the appellants arose from a combination of two circumstances. Neither appellant had a national insurance number at the point of claim, and the respondent made mistakes which unnecessarily delayed the appellant's claims from reaching the stage where the respondent would make universal credit payments. Neither appellant was invited to apply for an advance. Mrs Onakoya positively asked for one and was refused because she had no NIno.
Can I ask you, Mr. Droggle, is it right, Mr. Brown says this, that when the claims were ultimately paid, they dated back to the date of...
Oh, yes.
Yes.
Yes. I'll take your Lordship through the statutory scheme. That's probably the core of the case. But the way in which it works, you make a claim for benefit. That's now mandatory. It has been for some time, as the Upper Tribunal explains. That is not adjudicated. That is not adjudicated on in the case of a national insurance number case until the number is allocated. When it is allocated, the claim for benefit, and assuming as it is allocated and all the other conditions are satisfied, the claim for benefit is met, is decided in the claimant's favour, and benefit is paid from the date of claim onwards. So the issue, but it's a fairly sharp issue, is what you live on in the meantime.
Yes. No, I understand that.
Yeah. If there is a meantime, because payment isn't until 7 days after the assessment period.
Yes.
Often there won't be a meantime.
Well, there'll be a mean time between the date of claim, always in universal credit cases, a mean time between the date of claim and the commencement of payment, which in the normal course of events is about 5 weeks after the date of claim.
Yes, but when you get to the 5 week period, you get 5 weeks arrears.
Yes,
and then you get it monthly in arrears.
Exactly.
Yes.
Yes. Exactly. Oh yeah. Yes. Yes. So the complaint is about.
It's not about quantum. It's about timing.
Exactly. Absolutely. We say, in relation to both grounds 1, 2, and indeed 3, that the statutory scheme operates in the case of universal credit by dealing with the issue of the mean time, if I can put it like that, by the availability of advance payments. So universal credit is a benefit which goes to people who can be quite well off because it functions like the old form of tax relief. So relatively well off people in work will still have an element of universal credit, but it also functions in relation to what I think of as old subsistence benefits like supplementary benefit or
people who have no income at all.
Who've got no income at all. And so the scheme, we say, demands the availability of interim payments or a rapid decision on the national insurance number issue, one or the other, or you're left with a scheme which isn't providing a subsistence income at the time when it is required. And your lordships will have picked up the fact that in about 60% of universal credit cases which don't have the NIno complication, the national insurance number complication, an advance payment is made either on the same day or within 2 or 3 days, very soon after the date of claim. So it's the NIno complication which is producing the mean time. But the mean time is very important if you have no income. And we'll spend just a little bit of time on the evolution of the statutory scheme, but it helps to understand it if you realise that universal credit is a rather different animal from forerunner benefits like supplementary benefit or income support or job seekers allowance, which didn't have the kind of 5-week mean time. It's the
those of us who are not burdened with knowledge of the previous systems can put that to one side.
Well, I was about to say the same thing, but I thought you would then say, well, actually, even if we're not at the moment misled by our information, by any knowledge of the previous system, you positively want us to know about that. Is that right?
Yes, I mean, because at the time that the 1997 Act was enacted, which introduced the NIno requirement, we were dealing with the old scheme. We're not dealing with universal credit. And so when we come to the parliamentary material on the availability of advance payments, that's in a background which doesn't have the complication of quite such a built-in mean time as universal credit has. That just helps understand some of the drafting.
So how did it work with old benefits?
Well, you'd have the same position. Until the advent of the 1997 Act, there was no national insurance requirement. You will make a claim for benefit. Yep. Since 1998, that claim has to be decided by the Secretary of State. Used to be an adjudication officer, but that is a complication you can forget. He determines the claim, and benefit is put into payment as a result of that determination. Now, in the old system, that at least should operate in the space of days. There were various cases about whether it did operate in the space of days and what the consequences were. But those you can forget too. But universal credit, because it marries kind of PAYE PAYE style income assessments with benefit assessments has an inbuilt 5-week delay period.
So is this right? When the 1997 Act was enacted, for the various range of benefits, supplementary benefit and job seekers allowance and so on, that were then available, you make a claim, the Secretary of State, by 1998, the Secretary of State determines it, and as soon as it's determined, it's paid. And that should happen. Should happen. Within days.
As you can imagine, all sorts of complaints about it not happening, but yes, that's the target. And so you would, yes. Whereas now there has to be, we haven't put in all the material about the determination of the universal credit and the assessment period, all of it, but there has to be a delay between the making of the claim in a no-NIno, in a case which doesn't have the NIno complication. There's still a gap, hence the fact that in 60% of the cases where presumably the benefit is working as a subsistence benefit, an advance payment is made. In the cases of those who are rather better off, they don't have the need for the advance payment and no doubt don't apply for it.
Just flagging this up, I expect you'll come to it. I haven't seen in what we've been taken to in the papers the statutory provision, which I assume exists, about the date of payment as opposed to the date of entitlement. Everyone says, oh, it's 7 days after the end of the assessment period, and that's presumably based on a statutory provision. And I think indeed I saw a footnote reference to some regs, but we haven't. I'd like to see exactly how that's expressed.
Right. Okay. Well, I think it's the claims and payments reg. We'll make sure you've got a copy of that.
Thank you.
And just to put down this marker, that's a payment. I mean, if you're a social security lawyer, you have a claim, you have a determination on the claim by the Secretary of State, you have an award of benefit pursuant to that determination of the claim. The claim dies at that point. The claims and payments regs kick in, and the Secretary of State's under a duty to pay, and he pays universal credit. The advance payment regs are not dealing with the actual payment of universal credit, because there's no award of universal credit. It's a payment on account of. So you have claim, award, payment. I'm told.
Well, you actually said claim, determination, award.
Yes, exactly. An ability to make a payment on account of the final award of benefit, if you think it's likely to happen.
Well, the advance payments regime, as it was necessarily the case, is the whole point of it, skips both the determination and the award.
Exactly.
And
I mean, that's our point.
Yeah.
That's our point on ground one.
Yeah.
I'm told that the claims and payments regulations are in the bundle.
Oh, are they?
51.
No, well, that just shows. Never trust the court when they say how carefully they've read. But at least I told you I hadn't found it. Where is it?
51. So it's tab 5 if you've got tabs.
Yeah.
B5. Tab B5 of the authorities bundle, page 51, and it's 47.
Yes. 47.2.
It's 47.2. It's a 7-day period.
And assessment periods are calendar months, or?
Yes, I think they are calendar months.
I
think
Mr.
you and
Ravel
I
and I know all about this. Yes, they are
I
calendar.
can't remember what happened, but I do remember.
You've lost, I'm afraid.
Lots of little diagrams about why it mattered.
No, it was a case where there was a mismatch between someone being paid on a 28-day cycle and the entitlement to benefit being on
or a 7-day cycle or a 14-day cycle, as we
yes.
No,
So let's not refight that battle.
Yeah, it's a calendar month.
So it might be longer than 5 weeks. If you apply on the 5th of June, then your assessment period is what? June or July?
Well, can we be clear about your assessment period is not a particular calendar month. You mentioned a calendar month in the sense that it is...
what your income is for a month.
Yes.
I see. But then...
What it means is if you apply on the 5th of June, your assessment period expires at the end of the 4th of June. Not...
Also July.
Or July, sorry.
Yes.
And so your payment will be, assuming the Secretary of State takes his full 7 days, it'll be the 11th of every month. Am I getting that right?
Nods from behind me.
Oh, right. Well, in that case, but that wasn't what I meant by... I meant by calendar month the whole of June or the whole of July, but that's not how it works. No, it is a period of a month from the date of your claim.
Yes. But not 28 days.
No, not 28 days. A month means a month, I think.
Yes. Yes, so it's the 5th of June.
It's the corresponding date.
And what will be looked at is your income in that calendar month, which it doesn't really matter whether you receive it on the 6th of June or on the 4th or on the 3rd of July, as long as it's received in that month, or maybe it's several intervals during it, that is your income in that month.
Yes.
And then the problem, as you said in the other case, was someone who's paid the 28-day cycle had 1 month where they received 2 payments, and everyone.
So that was the relationship between.
Etc.
Itself in pure income terms doesn't matter, but the complication in that case, important complication, was the cap, was a benefits cap.
Yes, quite. Well, I shouldn't even have mentioned it, but at least it's enabled us to bring out the point which my lord was asking about.
Thank you.
Now, there's a further summary of the facts in both cases, which I don't think, unless your court wants me to go through in detail, I won't, but they are set out with reference in the Upper Tribunal decision at page 102. In the case of Ms Bui, paragraphs 8 through to 14.
Yeah. And there's Onakoya 15 to 20.
Yeah, and then 15 through to 20 in the other case.
One thing I did want to know, and again, I may be told it's in the bundle and I've missed it, is what the application form looks like. I appreciate it's on a screen rather than a piece of paper, that Ms Bui and Ms Onakoya will have filled in. I assume there are printouts available so we can see what they...
Yeah.
Probably nothing turns on it, but I just don't feel firm ground beneath my feet. For example, one point, to get ahead of myself, not to argue the substance, but to show why it might matter, is that the way 1BB is expressed is they will have applied for a NIno. Well, the only form we've seen isn't their application for a NIno, it's the internal EDC11, which is generated within the department. But presumably they have also applied for a NIno.
That's a problematic, I mean, your lordship's asking a very relevant question, because there isn't a simple answer to that. There is no form on which people apply for a NIno, and there's no prescribed machinery for applying for a NIno.
Well, this is what I just wanted to get to the bottom of. Nobody seems to be taking a point about it, but when you're coming to something fresh, you want to understand each step. But what I had assumed is, you asked a number of questions when you go online, and one would be, do you have a NIno? 2, if you don't have a NIno, do you want to, you should apply for one. Do you tick here if you want to apply for one and say what document?
I don't think...
But logically, if it isn't like that, how is the statute ever satisfied?
Well, your lordships will see in due course some observations by Commissioner Rowland very precisely on those lines. That's the context. You may have picked up already from the Upper Tribunal.
That was a long time ago, Commissioner Rowland.
Yeah, yes, it was, and it was under the old regime, and it was before the pandemic, before different forms of ID verification came along. But the wording of what, to answer the reason I'm mentioning this, is the wording of 1B anticipates that something that looks like an application form will be accompanied by documentation.
Yes.
But it's not as simple as that, because the initial contact in relation to either with NIno or without NIno claim involved at the time of Mr. Rowland's decision a face-to-face interview. And his point is, well, you can't recall information given in a face-to-face interview, information accompanying the form. It isn't. Yeah. And he uses that as a key to, as a pointer to the construction of 1B. I'll come to that. It's
right,
but
I think it's my fault perhaps for raising it now, and I didn't really want to tempt you into dealing with the substance of the point. You'll come back to that, but I think I want to ask early so that we can have it. Yeah. Ideally a printout of the form that, of what confronts someone when they're making an application online. Or if for some reason that isn't possible, at least a much clearer explanation of it than I have found in the evidence.
Well, what I'm going to...
We can obviously try and help with that. Can I just be clear about what the court's asking for, though? Because one can apply for a NIno just by going online and making an application, independently of an application for benefit.
Which I didn't know. Perhaps that's probably in there somewhere, but I hadn't picked it up.
Well, that's more common for those who are accessing the labour market. The process for the benefit-inspired NINOs, as they're being described here, as set out in the witness statement, is that ordinarily the individual will present the claim for benefits, and the Department of Work and Pensions officer will then initiate the NIno application themselves.
Well, I saw all that, but they haven't applied for NIno then.
No, exactly. So they know that the individual doesn't have a NIno and the application...
Yes, but you see my difficulty. The statute doesn't say the department decides to give them a NIno. It says an application has been made by the claimant for a NIno, and if that, unless you're saying, well, that's not really, everyone just conspires to ignore that, there must be a form in which they apply for a NIno.
No, it's treated as being the same application. So when one makes...
When you say it's treated as being, the statute doesn't allow you to treat something as being what it isn't.
How do you apply for universal credit? Do you have to do it online?
Yes.
You have to do it online?
Yes.
So there is an online form you fill in?
Yes.
Does it have a box saying, do you have a NIno?
I'll check.
I would assume,
my lord assumes yes, because
I would assume it says, do you have an NIno? The next question is, do you know what it is?
Yeah, exactly. So most
and,
cases...
and if you don't answer yes to either of those questions,
yes,
then the next question is, do you have I mean, what you'd expect is add here a driving license or a passport or something, upload something to tell us who you are.
And the step my lord has missed out, but I think the classic form would say, do you have an NIno? Or if not, what is it? If you have one but don't know what it is, please give us some information. If you don't have one, rubric says you need one and must apply for it. Tick here to apply for it.
Well, I think it's that point only, my lord, that may well be controversial, because I don't know. Certainly everything my Lord Justice Nugee says is absolutely right. We must have all of that. Does it have the box saying, do you wish to? It is almost by definition as if one's applying for benefits.
Well, look, I don't mind. It may not in any way be fatal to your case. No one's taken a point about it. That there is basically a sort of tacit acceptance that an application by someone who hasn't got an NIno must be treated as an application for a NIno.
Yes.
But I'd like just to be told that straight.
No, I understand.
And that is a departure from the words of the statute, but it might be fine in practice. But the first thing to do is to see actually what the form says. And rather surprisingly, it wasn't in the papers and the point isn't addressed.
Yes. The short reason why it's not in the papers is that it's not actually that straightforward in terms of having an old-fashioned paper application form. It's a series of online questions. Now,
I know, but I have actually come across this problem before, but we got over it in the end. I think in an immigration context, with online forms, it was surprisingly difficult to get, as it were, a suite of the pages, but I can't believe it doesn't exist.
No, of course. Well, that's all heard. Let me.
And if there are 20 questions, if there's a branch, and if you tick this, you have a different thing, that's fine. It may get a rather complicated thing, but I would ideally like all the pages that you would see, depending what choices you make. And if that is completely unwieldy, I would like a single page explanation of the sequence that's followed and the questions that are asked.
Understood.
Okay.
My understanding is that there isn't a form that invites the claimant to apply for a NIno,
No.
either as
I'm
part
getting
of
the
a
hint
wide-
that Mr. Brown doesn't think so either, but he isn't quite
willing to say
willing to say so yet.
But I think that is the position. That's my understanding. I'm just looking for somewhere, I'm pretty sure we said it in a couple of sentences in the skeleton. The department, of my understanding, and I'll take your lordships to the relevant part of the witness statements as part of the exposition of how the system works, treats a claim for benefit as the basis for what's called a benefit-inspired application for a NIno. That doesn't mean there's a box or
No, but
application.
it seems likely to be how it's panning out. But I just want to feel firm ground
Yeah, no,
beneath
I
our feet
understand.
on this. Yeah.
Presumably, information or evidence as what the person is required to provide is intended to encompass both external documents that you might supply, which would be evidence, and then what you write on the form, which would be information.
Yes.
But
It is
if
quite difficult to marry the language of
Yes.
1B with
Modern
any
practice.
form, let alone
Yeah.
an online form.
Yeah.
But if Mr. Brown is right, and I think that, well, hasn't said it yet, but if the way I suspect we're going to find out is right, certainly what you say is right, that there isn't actually a question on the form that asks, if you haven't got an NIno, do you want to apply for one? If so, tick here. And how do you supply? What's the machinery for supplying the necessary information and or evidence? In other contexts, with a sophisticated modern form, you'd be asked to upload a photograph of your passport or your driving license, and you can do that. But it doesn't sound as though that's what's done here. But if it isn't done, how are you supposed to supply the material that needs to be supplied?
Certainly pre-pandemic, the normal way the system worked, as I understand it, was that the claimant would be invited to attend a face-to-face interview, and there would be some indication to him or her as to what he should provide. And we'll see Mr. Rowland talking about this.
Bring your passport to the interview.
Yes, exactly.
Yeah.
And that process has been modified because the ability, we'll see the department's witness statement dealing with this, has been modified because of the difficulties in some circumstances of having face-to-face interviews during the course of the pandemic. But there's an initial identity verification stage when you make the claim for benefit and attend either the first face-to-face interview or its equivalent, or its modern post-pandemic equivalent. Now, there is an awkwardness which we say goes to the construction of one large B on ground 2, first ground you want me to argue. Because we say all of that demonstrates that the most that the claimant can do is turn up to the identification verification process, present him or herself, give information, and produce documents such as passport, driving license, or whatever it is. Once he's done that, then 1B is satisfied because you don't need to get to the actual allocation of a NIno. And if you did need to get to full formal verification and the actual verification and the actual allocation of a NIno, then one of the limbs of 1B becomes OTS. It's never needed because by the time the department's got all the information and has verified it, it can just allocate the NIno. It's just a matter of construction.
Yeah, well, we've
We're
seen that point. Yeah.
We're trying to deal with something in between. The point your lordship is putting to me about what happens at the beginning of the claim is important to all of that. Even though Mr. Brown and I don't necessarily know very precisely what the screen looks like. But what it isn't doing is producing an answer at the beginning of the claim about a verified NIno, verified information for a NIno. It's,
Yes, I mean, I did look. I'm afraid I largely took my account of the process from the skeletons and the judgment. I know more detail is given in the witness statement of Ms.
we've set out...
She's probably in court, so I shouldn't be rude and forget her name. But I may be doing her an injustice. This may all be... It's Miss Johnson, isn't it?
Yes, it's Miss Johnson. There's a lot more detail, but I'm not quite
but I'm
sure
not.
that it actually
I did look quickly to see if these questions were answered, and it didn't seem to me they were.
No. Well, one of the tasks I want to do before we come to the two specific grounds is to walk the court through the way we've described the process, which is obviously our understanding of it in the skeleton, but taking your lordships to Miss Johnston, I think.
Yeah. Okay.
Well,
I'm afraid this always happens.
See where we've got to at the end.
We take you off your course and probably slow things down, but at least you know in advance what we want. I'll try and keep quiet.
No, well, I think I've just shown your lordships the skeleton, the passages in the Upper Tribunal decision dealing with the facts. I don't think I need to go through those now. And as I think I've said sufficiently already, if your lordships glance at paragraph 6 of our skeleton, there's a reference to the 60% figure that I've already given your lordships. Universal credit paid in monthly instalments and in arrears. And there's a reference to Reg 47, which is what we've just looked at. It is page 30 of the core bundle. Paragraph 6 is my answer to the meantime point, in a way. And the footnote to the first sentence in paragraph 6 is to Regulation 47, which we have looked at.
Yeah, thank you.
And the 60% figure comes from Miss Johnston's witness statement at page 113 of the core bundle. Now, the next task that I was going to undertake, and I think I'll stay with it, is to take your lordship through the principal statutory provisions and then to the way in which the scheme is actually operated. That's acceptable way of doing it. So, if your lordships have our skeleton at page 33 of the core bundle, and the authorities bundle, starting place is section 1 of the Social Security Administration Act, and the lordships will find that set out
Behind tab 3.
behind tab 3. So we have entitlement to benefit dependent on claim, except in such cases as may be prescribed and subject to the following provisions of this section and to section 3 below. No person shall be entitled to any benefit unless, in addition to any other conditions relating to that benefit being satisfied, he makes a claim for it in the manner and within the time prescribed in relation to that benefit by regulations under this part of the Act. So just put down a marker because it may conceivably be important in relation to one point the Secretary of State makes. The claim, which is the foundation of the entitlement to benefit, has to be in accordance with the form prescribed in relation to that benefit by regulations. And at one stage, the various forerunner benefits did have a requirement that you state your national insurance number as part of the claim, but that's no longer the case. And then 1A, no person whose entitlement to benefit depends on his making a claim shall be entitled to that benefit unless subsection 1 below is satisfied in relation to both to the person making to the claim and to any other person in respect of whom he is claiming benefit. And then 1 large B, this subsection is satisfied in relation to a person if, and then A1 and 2, which your Lordship will have read, and then B is obviously the crucial provision. The person makes an application for a national insurance number to be allocated to him, which is accompanied by information or evidence enabling such a number to be so allocated. And we've explored already and will continue to explore whether it's possible to discern an application for the benefit, the number to be allocated to him, except by the simple submission of the claim for universal credit itself, which is what actually happens, right or wrongly. That is what my understanding is what actually happens.
Can I ask you, I don't think anything turns on it, under 1BA little 1, if you do have a national insurance number and you know what it is, you're also meant to accompany it with information or evidence establishing the number's been allocated to you. I know what my national insurance number is, but I have no information or evidence as to establishing it's been allocated to me. I just
well, I don't know anything more than my own personal experience, but I imagine that I have kicking around various documents from the DWP evidencing my monthly payment of retirement pension, for example, which unfortunately I now get, and that will have the national insurance number on it.
okay.
So I mean,
pretty well any correspondence from the taxman states your national insurance number, doesn't it?
yes, but certainly there will be there will be benefit.
And it's on your P60 and
Yes, that's right. And it's certainly in the benefits world, it will be on any previous claim for benefit or whatever.
I do remember in very long time ago, I think when I first got one, I got a letter from the department, whatever it then was, saying this is your, please keep safe. But I think no, I haven't.
No, but I certainly have.
No, but you're constantly reminded of it in any official. Once it is there,
I anticipate it could be satisfied by reference to official correspondence.
Thank you.
But this does raise the same point about practicalities. When you make your online claim and you want to, you have got a NIno. You state it, but you're required to give information or evidence establishing it's been allocated to you. So you think, well, I got that letter from the taxman last month. I'll take a picture of that and upload it. Is that how it's done? And if it isn't done, do you have to put it in the post box? Seems rather
I don't actually know. I assume that's how it's done. And certainly when we look at the original debate about the 1997 Act, which introduced large B, a concern was that it wasn't good enough just to say, I've got a national insurance number, and here it is. You had to show you were the person.
Yes.
The person.
But this, as you say, was introduced in 1997, before, I won't say before computers, but before online applications.
Before online applications.
So it must have been intended to be supplied in paper either as an interview or by being put in the post or left at the post office or however you made your claim.
Yeah, I've just been handed a note which makes sense. I'll read it because it may be probably the answer to your lordship's question, which is that we think, or those behind me think, that the department would accept that once he has verified a person is who he says he is, name, address, previous employer, and so on, that will be good enough to show that you're the person to whom the national insurance number relates. So it's not just benefits; it's probably a mass of personal information that tie the two together. And
that wouldn't, with respect, that wouldn't work, would it? A statement of the number, so you put your 8 digits or whatever it is, 9, and information evidence establishing, there's actually, it's not very well drafted, there should be a second that, establishing that that number has been allocated to the person. So it would have to be something with your name and address on it.
yes.
And the number.
The department can find a number if you give them the number.
The department has a big computer with everybody's name, address, and number on it.
Exactly right. I mean, that's the way I'm seeing it, like this second, as it were. The department's got a big computer. You go into your face-to-face interview at the beginning of the claim. You give them the number. You also produce your driving license, your last electricity bill, or whatever it is, showing proof of residence. They look up the number. And provided your personal details, which you're also giving as part of the verification process for the claim for it.
But no, that would be a Little Roman 2 situation. In a Little Roman 1 situation, you've got the number and you're asked to provide information tying you to that number.
Yes.
Little Roman 2 situation is where you have to go to the computer. So you say, I am Richard Drabble. And that enables the national insurance number allocated to him to be ascertained, because they look up Richard Drabble and your address, and they say, "Oh yes, your number is so and so." That's Roman 2, isn't it?
Well, if you don't have the number,
no, quite.
Then you're in Roman 2.
Quite. But
if you know the number,
if you know the number, then you've got to tie you to the number.
Yeah.
That doesn't.
Yeah, but you've got to give them something that does that.
Yes. Now, in the real world, I mean, in the actual process, which we'll be looking at in due course, that's all taking place in either the face-to-face interview or its post-pandemic equivalent. So you go in, as I understand Roman 1, go in, you have your number, you also have your evidence of address, place of residence, possibly previous employment, previous benefit history, and so on. And that will be good enough to show that the number has been the number that you have given them has been allocated to you.
That may be how it works in practice. As a matter of the statutes, I'm not quite sure that's good enough. If you just turn up and say, "I am Richard Drabble, and here's a letter to me at this address, and this is my number," I don't think that satisfies A1. You'd have to.
It only satisfies A1 because on the big computer, independently of my statement of my address, is the department's view of what my address is. Otherwise, it doesn't work. I completely agree. You've got to get a marriage between information on the big computer.
Okay. Well, we've probably explored this enough. You may be right.
Yeah. Now, your lordships already have my point about 1b little b, which is that it is looking to the future. What is required is you provide information or evidence enabling such a number to be allocated in the future. It bites at a point before 1b little a is satisfied axiomatically, otherwise it becomes completely odious. It bites before you have a number.
Well, 1b little b clearly envisages you don't have a number. But apart from that, I don't see why it's OTOs. I mean, if you didn't have 1b little b, you couldn't make a claim at all until you had a number. Whereas by putting in 1b little b, you can make a claim without a number. Once it's been determined and you've got the award, it dates back to the date of a claim. And if you didn't have little b, you couldn't do that because you could only claim once you've already got a number. So if you didn't have a number, you wouldn't even be able to make a claim at all.
That's biting another problem, which is does the information need to come in at the beginning of the claim, which on one reading it does, because of the wording of 1b little a.
The claim is accompanied.
Yes.
Oh, well,
But the rhetorical question which Mr. Rowland, amongst others, asked, well, what happens if you make a claim for benefit, and a week later you provide the material, or you find out 4 weeks later that you've been allocated a number? Strictly, you could never backdate, as Mr. Rowland says in his decision on that. But that is a nonsense. So that's just not. In any event, Section 1A is inserted by Section 19 of the Social Security Administration Fraud Act 1997, which is behind tab 5, page 27.
We don't need to go to that, do we? That's just for form's sake.
It just shows that's when it's inserted. Yeah. It is important to realise that it is inserted into the 1992 Act, and in a context in which Section 5, which is the empowering provision for, amongst other things, advance payments, already exists. So there's an immediate issue which is raised as to what is the effect of the insertion of Section 1, large A and large B into the 1992 Act on the power to make interim payment, advance payment regulations under Section 5. Now, the Upper Tribunal appears to proceed on the basis that the insertion of 1 large A and 1 large B precludes the making of advance payments before the final verification of the information that's been provided in relation to 1b little b. What we say, and this is the heart of ground 1, that makes a nonsense of the scheme, renders the interim payment scheme OTOs. Now, Section 5, an existing provision at the time of the enactment of 1b, 1a and 1b, is to be found at pages 15 and 16 of the authorities bundle. And on page 15, your Lordship will see that the heading to 5 is regulations about claims for and payments of benefit. And then over the page, little r, regulation may provide for the making of a payment on account of such a benefit in cases where it is impracticable for a claim to be made or determined immediately, or for an award to be determined or paid in full immediately, in cases of need or in cases where the Secretary of State determines in accordance with prescribed criteria that the payment can reasonably be expected to be recovered.
Now, that language was, we see, inserted in 2012. At least have I got that right? The little footnote 8, if you go to the notes.
That's something that's been deleted, I think. Oh, I see. Yes, yes. I want you to be probably right.
But you say there was an equivalent before then.
Yes. Yeah, Roger was right. We're missing a step.
I think we ought to see what it looked like. Well, I think, frankly, we ought to see what it looked like in 1992 and 1997.
Yeah, commencement date.
Possibly points in between, but those are the key dates.
Mm.
Can someone do that?
Yeah, we'll do that. Yes, I don't think we have that section. Ignoring the complication that we're not dealing with the original form of Section 5, my submission is that the form of Section 5 set out in the authorities bundle plainly would authorise a regulation providing for an advance payment, even if the one large A and one large B provisions have not yet been shown to be satisfied in the sense of verified.
The 2012 Act, which inserted R in its present form, or substituted, as we're told, is the Act which introduces universal credit, isn't it?
Yes. Yes, there's a short answer to that.
Okay.
So the actual regs now in force, the advance payment regs, are at page 49.
Yep.
And your lordships will have seen this. Payment on account of benefit where there's no award of benefit. The Secretary of State may make a payment on account of benefit to A, either of paragraphs 2 or 3 applies. It appears the Secretary of State likely that the conditions of entitlement for benefit are satisfied or will be satisfied during the period in respect of which payment is to be made. And your lordships will see the footnote and the summary of the effect of the words in brackets. And the Secretary of State is satisfied that A is in financial need. B, this paragraph applies where A has made a claim for benefit, but the claim has not yet been determined. So on a very straightforward basis, we say that there's a virus to make that regulation. See Section 5. Good enough for immediate purpose to say in its present form. And those regulations permit the payment on account of benefit where the claim has not been determined, see subsection 2, and it appears to the Secretary of State likely that the conditions for entitlement are satisfied.
This applies just as much to cases where there isn't a NIno problem.
Yes.
And indeed it applies to legacy benefits as well as to...
Indeed. It is routinely applied in cases where there isn't a NIno problem. That's the 60% figure of where
Yes,
the advance
right.
payments are made. And I mean, in part of our case on advance payments, there's simply nothing in the wording to suggest that you get a different result when you're dealing with an absent of verification about the NIno.
And the reference to the claim not having yet been determined, you said earlier that the timeline is claim, determination, award, payment.
Yes.
The determination is, I think you referred to determination by the Secretary of State.
Yes.
Since 1998, under Section 8 of the 1998 Act.
Yes.
So a claim is just that, it's a claim,
Yes.
and the Secretary of State, through a whole range of teams, looks at the claim and decides is it a good one or not.
Yes.
And that's the determination process, and that necessarily takes a bit of time.
That's the determination process. But what happens? Yes, exactly. So in a no NIno problem case, if I can call it that, you put in your claim. It goes to the universal credit team. This is a matter of practice, who ascertain that you are who you say you are, that your income information.
You have to tick all the boxes.
Yes, indeed. I'll show your lordship the detail of that in due course. At the end of that, in a no NIno problem case, the Secretary of State makes a Section 8 decision,
and that leads to
an award of benefit which goes back to the date of claim, and claim dies, and if you want to claim again, you have to make a new claim, and it's all over. The problem with the NIno problem case is the Secretary of State doesn't make his Section 8 decision until he's verified the NIno information.
But why is that? I mean, I see why it's a practical problem because you have this gap. But I don't see why it's a problem in interpretation. Whenever you make a claim, you assert, I satisfy this condition, that I'm over 18, I'm resident in Great Britain, these are my financial situation, this is my NIno, or if I don't have one, this is the information that I've got which entitles the NIno to be allocated. Now, whatever the conditions are, the Secretary of State has to check that they are in fact satisfied, and that's the determination process under Section 8. That's bound to take a bit of time. And if it's satisfied, claim dates back to the date of claim. And so I don't understand what the difficulty is in the sense of saying you put in a no NIno case the information which you say is enough, you the claimant says enough, the Secretary of State then has to verify it. What's wrong with that? Just as he verifies everything else.
Well, it depends whether we're talking about ground 1 or ground 2. The problem on the advance payment.
I understand that. That's ground 1. But on the ground 2, I don't understand what the problem is.
Well, ground 2 it comes back to the wording of 1B.
Okay, maybe I'm taking you out of your course.
It comes back to the wording of 1B. Yeah. What you have, and I think one needs to read it together with what Mr. Moden says about it. Yeah. On the assumption that you provided the information which enables an insurance number to be allocated in advance, there is no prohibition on determining the claim absent verification. You don't need to you, Secretary of State, don't need to verify because you have got all the information that enables the claim to be allocated.
It depends on what you have to. It depends on what 1B.
But how does the second?
That is the construction issue. On
okay. Well, I don't want to interrupt where you were. I just saw that the bit you were showing us had a reference to determination, and that's the reference to Secretary of State determining under Section 8.
I don't want to doubt that at all. That must be, but just to flag up a technical difficulty to which there may be an answer. The regs use the language of determination. Section 8 uses the language of decision. No doubt they mean the same thing, but these are very carefully drafted statutes. There may be some reason why Section 8 could just as well have been called determinations by the Secretary of State. If there is a chain that defines determination as a decision under Section 8 or something, I think we ought to know it so we can set it all out.
Yeah, it's not easy.
No, well, you can say that the Secretary of State should do it since it's her legislation, his legislation.
Yeah, well, that's very tempting.
Well, anyway, I just like to be able to pin all these things down. Likewise, you say there's a distinction between a determination and an award. And of course, conceptually, determination leads to an award, but actually, in the sense, they're the same thing, aren't they? Well, what's the difference between determination and an award?
Awards, I spent more of my life than I care to remember trying to work out what an award truly was, because there isn't a single piece of
Is the language of award, we haven't seen it so far.
I don't think you will struggle to find a precise reference.
So why are we using it?
Because, well, there are lots of provisions that assume that an award has been made. So supposing this is just kind of off the top of my head, but I mean, if it may help. You make your claim for benefit. Secretary of State makes a decision on the claim, which in lots of contexts will be called a determination.
Yeah.
He will say, sometimes he will make an indefinite award, and some of the regulations talk about that, i.e. there isn't a specific time limit to the award. It just runs on from from assessment period to assessment period, if we're talking universal credit. Sometimes he will make a fixed term award. Now, then there are provisions also in the 1998 Act enabling revision or supersession to have different temporal effects of the original Section 8 decision, to call it that. They will all be determinations.
I think this is perhaps more than I need to know, certainly more than I can take in. And I was merely asking a purely technical question, just so that we can use the right language in our judgments and see where it's all based. Now, I raised the point about what's a decision and what's a determination.
Yeah.
And I would just quite like to know if there's somewhere a definition of what an award is. And if you say there isn't, well, we'll have to cope if... Well, I'm not sure the word is used in any of the provisions that we are dealing with.
I don't think it is. No, I don't think it is.
But it came in your submission, which is why I was...
It does appear in Regulation 5, doesn't it? Which is titled Payment on Account of Benefit where there is no award of benefit.
Ah, right, well, there you are. My lord is right and I'm wrong.
It appears in the last line of the regulation as well. An award of benefit has not been made.
Yes. I am not trying to make difficulties of substance. I'm just trying to be accurate so that we use the words correctly.
Right.
I think the right way forward on this is for the two of you or your juniors to get your heads together over lunch, ideally, or in the next 24 hours, if not, and just, it may prove to be more difficult than it should, but just say, these are the key concepts and where they're defined and what provisions, and then we'll use them accurately. I don't think we're going to be able to deal with it on our feet sensibly.
Yeah. Can I just give your lordships a page reference, specifically not invite you to go to it now?
Right.
But page 238, page 238 of the core bundle. There is a summary by our side of the legislative scheme, which explains what we think is meant by an award.
Oh, well, I'm sure that'll be helpful. If Mr. Ryan agrees with that, then you can just say so, not now, but at an appropriate time. Which paragraphs? I've got
238.
Yeah, which paragraphs?
It's 9.1. An award means an excellent decision that a claimant's entitled to the benefit.
Oh, I see. That's very helpful. It's not actually statutory, but it's it's this court, which is even better. Thank you. Right. Well, you're struggling on, despite being constantly distracted. You're taking us through the relevant legislative provisions. I think where we left the tracks was on the regs Do you want any more you need to say about them? The advance payment regs.
Yes. We have in the bundles that I've got, they're not chronologically complete, the forerunners of Reg 5, or some of them. If I can just show your lordships. Page 41.
Sorry, page 41 of what? Sorry? Somebody coughed.
It actually reads 41 of the authorities bundle. That's confusing. Let me catch up with myself.
1988 regs.
Yeah. I think that the regs that we find at page 41 are the interim payment regs that were in force at the time of the enactment of the 1997 insertion of one large B and one large A, but I need part of the chronological check to double check that. And then we have at page 43
So in fact, the language of interim payment, if you're right, I dare say you are, I'm sure you are, the language of interim payment has been abandoned in the later legislation. Is that right? Reg 5 doesn't seem to use the language of interim payment unless I'm missing it.
it comes in the body of Reg 5, payment on account.
It also doesn't use the word likely unless I've missed it.
No, it doesn't.
All that the Secretary of State had to be satisfied of was that a person might be entitled, and it was impracticable for it to be determined immediately.
Yes. Yes. So
Well, is that an aid to construction?
it depends whether we're dealing with ground 1 or ground 2, doesn't it?
On ground 1.
On ground 1, well, I certainly would submit that the Upper Tribunal were much too dogmatic about statutory instruments that were part of the body of law at the time of the enactment, not being an aid to construction. But
No, sorry, that's ground 2. But on ground 1, there's a meaning about there's obviously we've got to decide what's meant by likely.
Yes.
It originally said what we looked as though it's the predecessor said might. Now you could argue either way. Might perhaps is a more general, less restrictive approach than likely. Certainly, if likely is meant to mean 50% plus 1.
Yes.
The fact that there was a change at some point between 1998 and 1988 and 2013 to the language of likely, you could say that they meant to tighten it up, or it could mean there's no particular reason to believe they were trying to change the test. They just used different words.
Yes.
In which case, it would be quite helpful to you to know that the language of 1988 was might. That's what I'm exploring.
Yes. My principal contention is I don't mind, because when we come to the next stage of my submissions and we see what actually happens when the claim is made, we get to a situation where the universal credit team, as opposed to the NIno verification team, are satisfied that you are who you are, that you live where you say you live, that you are allowed recourse to public funds, that you are habitually resident, and so on. Once you've got to that stage, which whether likely means 50%, sorry, whether the test in the regs is 50% plus 1, or some slightly tougher version like likely to be satisfied, either of them are going to be met in a very large number of cases. In other words, if the Secretary of State is satisfied that all the conditions for entitlement, including your identity and your age and your immigration status and your the fact that you are habitually resident, if all that is made good, it is a small step to say that the conditions of 1b, little b, are likely to be satisfied. It's just conceivable they might not be, because you might be making a fraudulent claim, but that's true in a large number of different circumstances. Now, the Secretary of State persuaded the Upper Tribunal in paragraph 59 of its decision that likely was a neutral criterion. I stared at that and struggled to understand what's actually meant by that. And that's the heart of ground 1. So my answer to your Lordship's question, maybe we could explain, I don't actually really mind whether it's 50% plus 1 or some tougher version.
Well, I was actually thinking some lighter. I mean, likely, classically in the ordinary common law context, the two possible meanings of likely are 50% plus 1, which is the tougher of the two,
Yeah.
or on the cards sort of thing that might happen, which is the less restrictive. And there's case law saying it depends on the context which it is. I was wrong to put it. It's not might be, it's maybe, but I think it's the same point.
Yes. Yeah. It's enough for this case for me to say that once you've gone through the situation where the Secretary of State is satisfied as he would be in all non-NIno complication cases, that the conditions for entitlement are likely to be made out, that's good enough. Which I won't, but my note told me next, in relation to ground 1, to take your Lordship to the pleadings in the court below, but I think I'll miss that for now and see where we get to. I reserve the right to go back.
Just before we... You took us to page 41. We have got the same reg in a later stage on page 43. Did you... If you told us that, I'm sorry, I didn't pick it up. It looks so it went through 10 versions between 1998 and when it was finally repealed. It's probably not going to be profitable to us to know.
I was slightly worried that your Lordships were going to ask for...
No, I'm not. If it was profitable for us to know what the intervening versions look like, I'm sure you would have produced them. I'm just checking. It's basically, although it's not a lot more complicated, it still talks about interim payments, and it still talks about is or may be entitled.
Yes, there is a point on the version which is at page 43, I think. Make sure.
Yes, it introduces a.
It specifically refers to in regulation 2.1a.
Yes, now I can see it introduces reference to the. Well, it doesn't introduce. Yes, that's right. They were in fact introduced in 2005. If we look at the end. Anyway, there we are.
Yeah. So I mean, I have a point that indicates that the draftsman of the form we're looking at on page 43 certainly didn't think that one large B ruled out the interim payments if you didn't satisfy, if you hadn't had a finally verified application for a national insurance number. No. That is only secondary legislation, and you can't determine the meaning of the primary provision, I agree. Now, can I then move to how it all actually works? Your Lordships will go to our skeleton at paragraph 7, page 31 of the core bundle. We say the respondent operates his universal credit decision-making process in 2 stages. Stage 1, the respondent decides on the balance of probabilities whether, leaving aside the NIno issue, the claimant is eligible for universal credit. And that's reference core bundle 120 to defendant's skeleton. But then the 2 references to SP 14 are to a witness statement of Miss Johnston in common form. And Roman 1 is important, identity verification. We'll see what's meant by that in due course. 2, a determination as to whether a claimant passes the habitual residence test. 3, a determination as to whether the claimant meets the other criteria for universal credit eligibility, which are primarily contained in section 4. This involves assessing various factors such as a person's age, educational status, claimant commitment, requirements, etc. And then if the claimant has a NIno, he or she will, once the above steps are complete, be able to receive payment of universal credit. The amount of entitlement will be calculated at the end of the assessment period by reference to the claimant's circumstances during the period. Now, if you go to the witness statement at page 114 of the supplementary bundle. Ms Johnston says, when a claimant, this is paragraph 19, the claimant makes a universal credit claim, eligibility will first be ascertained under the Welfare Reform Act. To be eligible, a claimant must meet the basic conditions of universal credit entitlement, including satisfying the lower and upper age limit requirements.
Yeah, well, we can read all that,
Exactly,
yeah.
Exactly. Last sentence of 19, process includes verifying their identity to universal credit standards and completing a habitual residency test. Then once it's determined that a claimant meets the basic conditions of universal credit eligibility, the application form EDC.
So as I read it as 11, but it looks as EDCI1.
I don't think it is 11.
Sorry?
I don't think it is 11. I think it's
No, it looks
capital,
like...
it's a capital I, little
Yes, okay.
numeral 1, I think. What it stands for, I don't know. Lordship can read on to 23.17.
Yeah.
23.7 rather. We'll see that 23.4 says the Universal Credit Agent completes the EDC 1I1 form. The Lordships will find that at page 169. In the supplementary bundle.
Yeah.
By the time this form is completed by the Universal Credit Agent, we know from the very first line at the top of the page on 169 that he thinks entitlement to benefit has been established before referral to the DWP NIno Centre.
Yeah.
And your Lordships will also see in the lower of the two boxes there's been a process of ID verification. Up 4 lines up, 4 or 5 lines up from the bottom, ID verified by, and there's an online tick box.
But is that are you suggesting that that is separate from is that a reference to the ID verification that will already have taken place as part of this entitlement to benefit?
That's my understanding.
Yes.
I mean, simply by looking at the form, but that is my understanding.
Okay.
Yes.
But
my point is fitting it into the advance payment provisions. At this stage, the Universal Credit Team is satisfied that there is eligibility for benefit, satisfied they know who they're dealing with. And so to go back to the use of the word likely, we say that it's fanciful to say it's not likely. The one large b, little b condition has not been made out. Going back to our skeleton, by the end of stage 1, eligibility for benefit has been established and we know who we're dealing with.
will you be coming back to the next section of Miss Johnson's
stage
state?
2.
No. Page 2 of what?
Sorry, stage 2 on our
stage
skeleton at page 31.
Yes, I see. Okay. Yep. No problem.
Is us taking your Lordship to our understanding of the position. If a claimant has no NIno, then after stage 1 is complete, the respondent moves to stage 2, the NIno allocation stage. NIno allocation stage involves an internal referral to the Universal Credit Team, which handled claimant's case at stage 1, to a different team as the NIno allocation stage. And if your Lordships will look at page 153, which is the reference that's given there, 153 of the supplementary bundle.
Yep.
We're in a document called Spotlight on Claimant Without a National Insurance Number.
Yeah.
Heading at the top of the page. Then the background sets out, and the point I've been rather labouring is set out in the penultimate paragraph on page 153. Entitlement to benefit must be established before referral to the National Insurance Number Allocation Scheme.
Yeah, got the point.
Yeah. And it's also relevant to round 3. We haven't really raised at all so far, which is no irrational or perverse the Secretary of State not to start, assuming that he's right on construction of both the advance payment provisions and of one large B, then the obvious thing to do to satisfy the statutory scheme is to start verifying them, at the very beginning of the process, instead of waiting until the very end of the process with the concordant delays. Over the page at 154,
Yeah.
under the heading completing EDCI1 form for claimants without a national insurance number, agents, and I think that must mean in context, universal credit agent, completing an EDCI1 form without a national insurance number must add 6 biographical questions and correct answers to the additional relevant information section. And there they are, you can see them set out. They come down on the drop-down scheme. My point remains the same. By the time this form is completed in the universal credit section, all of that information is available, and this material, the form of judgment on whether it's likely the condition for entitlement is satisfied.
Sorry, I'm not quite hearing you. All the
By the time this form is completed, the EDC, all the information necessary to determine the claim has been provided. And it's sufficient for my purposes to say that whatever the precise meaning of the word likely, there's ample material to say whether it's likely that the 1B, it'll be, criteria is fulfilled. Your Lordship will see set out towards the footer, page 31 in our skeleton, 31 of the core bundle in our skeleton. The specific task for NIno, for the NIno team.
Yeah. Now that interviews, face-to-face interviews, so-called, sorry, not face-to-face, now that telephone interviews are the norm, I think are universal as far as I read Ms Johnson's statement.
I don't think that's right.
Oh, sorry. Well, that's what I just wanted to look at. If you look at her statement, page 115 of the supplementary bundle, very bottom of the page, para 26. She sets out all the steps that are followed. And 26.2 says, if a NIno is not traced, I mean, first of all, they check, by definition, this is someone the person thinks they don't have a NIno, but obviously step one is to check whether they really have. So step two, if a NIno is not traced, an agent-led outbound telephone interview is conducted to complete the NIno application.
Yes, so, that's by the NIno team.
Yes. It's
crucial to bear in mind that before you get there...
No, I've understood all that.
It would normally have been a face-to-face interview.
But that's stage one.
Stage one.
I'm talking about stage two.
Yes, so that from my point of view, and this is relevant to both grounds 1 and 2, what is happening is a process which would normally involve a face-to-face interview, although modified because of the pandemic, at stage 1 by the Universal Credit Team, but with the production of documents and so on. And then a second set of verification by the NIno team.
Well, I've got that point. I understand that point, but I'm just trying to work out what happens. I thought you weren't so much making submissions, though you've been tempted into doing so. You were just factually telling us what happened.
Yes, sure.
And 26.2, it does say a telephone interview is conducted to complete the NIno application. The NIno application collects personal information, in particular previous names and addresses. Applicants are also asked to provide proof of their identity, immigration. How do they do that in a telephone interview?
Well, I can only read these words.
No, I know, but in a sense, I'm flagging it up for Mr. Brown to deal with, because this all feeds back into what 1BB requires. Yes. You've got to supply evidence, information you can supply over the phone, but evidence, if that means documentary evidence, which is pretty clear it does, can't be.
Yes.
If it had been a face-to-face interview, you could have brought it. And just one other question, Mr. Brown, to answer, not now. Everyone's saying, you're saying, I'm sure rightly, this has all changed as a result of the pandemic. Has it gone back to face-to-face interviews since?
I personally can't do more.
No, okay. I'm flagging these queries up.
Yeah. Paragraph 23 of Miss Johnston, which is at page 114. It's 23.1 through to 23.3, all dealing with the pre-EDC1, I1, it is. So they're all being done by the Universal Credit Agents.
Yeah, okay. Anyway, we've got to plough on. I'm just...
Yes.
How much more of your process are we going?
I think that is the process.
Right. Thank you.
Can I then, before coming to the 3 specific grounds, take your lordships to the Upper Tribunal decision, which is at page 19, specifically those pages which are at page 99. The decision starts at page 99, paragraphs 40 to 45. Summarise the parties' submissions. Your lordships will see in particular the references paragraphs 42 and 43.
Yeah.
To the advance payments regulation. And paragraph 45 records Mr. Brown's submission on the meaning of the advance payment regulation. paragraphs 54 through to 56. The central conclusions on what is ground 2.
Yeah. Yeah, we have read this. So what's if you're trying to make particular points, please do. But
I think
telling us what's in there doesn't.
The only further
help.
point is paragraph 59, which is the central paragraph on the advance payments issue. I think I already made my submissions about that.
Yeah.
So can I then go to the way in which we put ground 2? If your lordships will look at paragraph 42, so page 42 of the core bundle, we are skeleton. Four through to 46 summarises the approach of the UT, and we'll just be looking at that. '47 is our submission on the forward-looking nature of section 1B.
Can you explain to me what you mean by forward-looking meaning and allocation would in principle be possible?
You bear in mind that the provision expressly does not require anything more than the provision of the information which in the future will enable the number to be allocated.
Would you accept that that has to be genuine information which does enable? If you put in a forged passport, this was the point the UT made.
Yes.
Do you satisfy 1BB or not?
No, you don't.
No, you don't, because it doesn't.
Yes,
the box.
I think the moment has come to look at Mark Rowland, Mr. Commissioner Rowland's decision, because this is the basis on which we put the ground 2 argument, and all of this is explored. Can I invite your lordship to do that? Your lordships will go to the authority model. You'll find Mr. Commissioner Rowland's decision starting at page 453 towards the back behind tab 11. And in fact, there's a passage which starts at paragraph 28, page 461. And he says in paragraph 28, in any event, there are further difficulties within...
So the date of this is 2008, isn't it? Yeah. So we're dealing with it's a pre-universal credit world.
Oh, absolutely.
But it's a 1992 Act world. Yeah.
Yes. Further difficulties with section 1(b)(b). First, it's plain that it is not intended that the application must always have been made before the first day in respect of which benefit is claimed. It is sufficient that it has been made before the relevant decision is made. Otherwise, it will become virtually impossible to backdate claims. In this respect, section 1(1) large b is similar to section 1(1), where it's even more obvious that a claim need not have been made before the first day in respect of which benefit is claimed. More important is the issue at the heart of this appeal, what is meant by information or evidence enabling a national insurance number to be so allocated. The problem, which appears not to have been anticipated by the draftsman, is that it is not possible for a claimant to satisfy the Secretary of State that the national insurance number should be allocated by way of a postal application. What the Secretary of State actually requires in order to allocate a national insurance number is sufficient evidence to show that the applicant does not already have a national insurance number, i.e. the evidence that would be required under 1BA Roman 2, so as to enable a national insurance number to be found if one had been allocated. Information that a claim for benefit requiring application for a national insurance number has been or is to be made, and information as to identity so the Secretary of State can be satisfied that the claimant is genuine. The information as to identity that is the difficulty. A local authority should satisfy itself as to the identity of those in respect of whom benefit is claimed, but the Secretary of State does not rely on the local authority in doing so. Instead, the person concerned is called to an evidence of identity interview at the job centre and is told what evidence to bring, it being plain that photocopies are not accepted. The interview enables the person's face to be compared with a photograph in the passport, makes it unnecessary for valuable original documents as to identity to be sent by post, and enables a person to be questioned to test his or her statements. However, it's not been the understanding of the parties that the application is only made at the interview. Against this background, the phrase information or evidence enabling a national insurance number to be so allocated cannot, in my judgment, extend to information or evidence provided at the interview. It is clear from the fact that the application must be accompanied by information and evidence. In any event, if Parliament had intended to include the information that is provided at interview, it would, in my view, simply have made entitlement conditional on a national insurance number being allocated, which it has deliberately not done so as not to delay the award of benefit. Moreover, the legislation does not specify what information or evidence must be sent with the application because the various regulation of the 2001 regs does not apply. A person can be expected to send only what he or she has been told to send, and the source of that information is likely to be those that could have been sent in advance and has been omitted, such as, for example, information as the applicant's date of birth, which is not included with the information originally sent by the local authority on behalf of the claimant's husband in this case. It cannot be right that a claimant should be penalised because a local authority acted on her husband's behalf neglects to include information that can perfectly well be provided subsequently. In my judgment, the information and evidence mentioned in the legislation is only that information and evidence that the person concerned could reasonably have been expected to send when the application was made. Follows that I do not entirely accept.
Sorry, I hadn't realised you were going to read. So how much more
Next
do you want
paragraph.
to... Sorry, just the next
31.
paragraph.
Oh, maybe 32. Yeah, 32. Or can I just ask you to read 31 and 32?
Okay. Yeah.
So, attempting to answer the question, if you provide a false passport and that is subsequently discovered, the Secretary of State has information on which he can hold that the condition in 1 large B is satisfied, but will immediately, upon discovery of the fraud, have the power to supersede or revise the decision, which are technical terms of art under the Social Security legislation.
Under what provision is that?
It's all in the 98 Act. It will be sections 10 and 12, I think, of the 1990.
Well, I think it would be, because I'm interested in this question of what happens if, on the different parties' submissions, what happens if an entitlement arises on the submission of something which turns out to be false.
I thought you said submission of a false passport did not satisfy 1BP.
Yes, but you know that in retrospect. I mean, that's
Well, that's...
that's I think that was lying behind.
Well, I think there's a difference between saying it doesn't satisfy And if you make an award on a false basis and pay on a false basis, you can then do something about it and get the money back. And saying a false passport does not satisfy 1BB. And I'm not, at the moment, entirely sure what your position is.
The Secretary of State, I mean, let's just answer it. The Secretary of State confronted with an application which on its face entitles him to say that the 1B condition is met, can lawfully make an award of benefit if it transpires that the passport is forged, is submitted fraudulently, then the machinery exists, as Mr. Rowland points out in paragraph 31, to revise or supersede that decision and get the money back.
Well, that's a different point. I, like my lord, had understood your answer to mean, but it puzzled me how that was consistent with your case, that the fact that it was, albeit only subsequently discovered, forged, meant that there was no entitlement. But logically your position has to be, and I think now is, that an entitlement does arise, and an entitlement, and they have to go on being paid until the verification process discovers that it's forged, in which case there's machinery to get the money back. I didn't quite know what that machinery looked like.
Well,
the least it will say is you can have the money back, which you probably have at common law anyway, but it might say it's to be treated as if it had never been made.
Yes, it does. I think we better provide the statutory provisions that relate to supersession and revision, which is what Mr. Rowland is talking about in the middle of paragraph 31.
Yes, well, I think you bet. But
because if you supersede a decision, then you can supersede it with effect from day one, so that the decision on the award, sorry, the decision making the award ceases to be, as it were.
Yes, it's as it were, it's retrospectively avoided.
Yes.
But that's fine. But that's only because that machinery exists.
Yes.
Until that moment, there will be an entitlement, albeit that the passport is in fact forged.
Yes, but you can't answer these questions about the Social Security legislative scheme in isolation. The scheme involves a duty on the Secretary of State to make the decision under Section 8, as we've seen, an ability of the Secretary of State to either revise or supersede that decision with various effects if it becomes clear that that decision was wrong. Now, wrong, it seems to me to be, with respect, kind of dancing on a pinhead to argue about whether...
No, I don't think this is an academic point. As my understanding is, this is your ground too, that all you need to do to satisfy 1BB is put forward evidence which on its face appears to show you're entitled to a NIno. Whereas the Secretary of State's cases, what you have to do is put forward evidence which does in fact entitle you to a NIno. And those are two completely different analyses. And my understanding is that is ground two. And I understand entirely, but if you're right and all you have to do is put forward evidence which prima facie looks as if it satisfies entitlement to a NIno, then you are entitled. You have ticked that box, the 1BB box, but the Secretary of State has powers to supersede it on discovery of the fraud. But that's quite a different analysis from saying, if you put forward a false passport, you have not satisfied 1BB.
The construction that says that's wrong has to deal with the policy perspective set out in paragraph 30 of Mr. Rowland's submission, of Mr. Rowland's decision, namely that the legislation is deliberately couched in terms that are short of a requirement that the NIno be allocated.
I mean,
You cross the hurdle in one large B or whatever it is when you submit documents which, on the face of it, satisfy the requirements of the legislation.
Speaking for myself, and possibly not for my lords, as a matter simply of first impression of the way it's drafted, I see a great deal of force in that.
Yes.
The condition is expressed in terms of making an application, accompanied by certain documents. And that's the strength of your case. The weakness of your case is that it leads to a result that Parliament cannot have intended, and namely that there is an entitlement on the basis of forged documents, and you can go on being paid on the basis of forged documents unless and until the fraud is discovered. And that being a surprising result, what the Secretary of State says is that full force has to be given to the words enabling the whatever the phrase
Whatever
is.
the phrase is.
NIno to be allocated.
Yes, enabling and reading the whole thing together, it basically means there's an entitlement only at the point at which there is an allocation.
Well, with respect, I simply don't understand how you get to that last proposition. It's not there in the language.
Well, I don't think the Secretary of State's case is that you're only entitled once the NINO's been allocated. His case is you're entitled if you put in a qualifying application.
Yes.
And it must be, the entitlement must arise at that stage because of the dating back point. It's only if you make a valid claim and you're entitled to it at the time you make the claim that you can date the award back to the date of the claim. So the Secretary of State does not say, as I understand it, your right to payment, your right to UC only arises once you've got a NINO. What he says is your right to UC arises if you put a qualifying claim in. In order for it to be a qualifying claim, it has to be accompanied which evidences your entitlement to a NINO. The Secretary of State has to decide that claim. That means they have to verify whether the evidence does in fact entitle you to a NINO. Once they've verified it, they will in fact give you a NINO, because once you've done the verification, you're in a position to allocate one, so you might as well allocate one. But it's not because that's a precondition of being entitled to the benefit. The entitlement to the benefit dates back to when you put the form in. But it's that until you've checked that you have put the right evidence in, evidence which is a true passport, not a forged passport, you can't know whether the claim is a good one or not. But if it is a good one, it was a good one when you put it in. That's as I understand it.
Yeah, but I mean, as Lord Justice Underhill puts to me, I mean, if you simply stay with the language of the statute, it requires an application that has all of its own difficulties, which we've been exploring. It needs to be accompanied by certain documentation. At that stage, an important policy objective has been fulfilled because the information is there in front of the universal credit team to establish that you are who you say you are in all those checks. And if, despite all that, the NINO verification process, which is not a creature of statute, produces a different answer, then so be it. As the machinery of the overall statutes, the 1998 Act in particular, is well able to deal with that situation. So what you don't do is what Mr. Rowland's decision was intended to avoid: put off the payment of benefit, full stop, until you've gone through a verification process which is not provided for in express terms by the statute, and which isn't suggested by the statutory language.
But Section 8 says it's for the Secretary of State to decide a claim.
Yes.
Until the claim's been decided, you can't make an award. That's where you started.
Yes.
And deciding a claim must mean deciding whether what the claimant claims to be the case is the case. Is the claimant aged over 18? Is the claimant resident in Great Britain? Is the claimant somebody who, although they don't have a NINO, is entitled to a NINO? Why isn't that all part of what the Secretary of State has to decide before making the award?
because of the reasoning in the second half of paragraph 30 at the foot of page 461 of Mr. Rowland's decision. Let's have another look at that.
But the difficulty I have with that is if you made entitlement conditional and national insurance number being allocated, it would have a different effect on the quantum of your benefit, because your benefit would only run from the date of allocation.
No.
And in your case, in this case, the way the Secretary of State actually operates it, your entitlement to benefit runs from the date of a claim, provided it's a good claim. And the process of verification is just checking that it is a good claim. And that's quite different from saying you only get an entitlement to benefit once your national insurance number has been allocated, because in that case your claim would only date back to the date of allocation, and we know here it doesn't date back to the date of allocation, it dates back to the date of claim. And that's a significant difference. So it's perfectly understandable why Parliament has not said you only get credit once you've got an entitlement to credit once you've got a national insurance number. It wants people who don't have national insurance numbers still to be able to apply, and if it's a good claim, still to be paid. But the Secretary of State has to decide the claim. Why doesn't that involve deciding if it's a good claim or not?
But it has to decide the claim on the basis of the statutory. I mean, it comes back to the meaning of.
So what does 1BB require?
Yes, exactly.
And your case, if I've understood it correctly, your case is 1BB doesn't require evidence which actually proves you're entitled to a national insurance number, but evidence which on its face looks as if it proves you're entitled to a national insurance number, whether it actually does or not.
Well, yes, in the sense that for the reasons I've been trying to explain, once 1B is inserted into a scheme, the existing social security legislation, which requires the Secretary of State to make a decision, it sets out a perfectly sensible policy requirement that you provide the information that would enable a national insurance number to be allocated. That's important. It also provides a linchpin for saying that the claim can be superseded or revised if it turns out to be wrong. And that is what Parliament has actually enacted. It as a perfectly coherent position for Parliament to have taken. And there's nothing in the language about national insurance numbers that suggests that there's anything different about the satisfaction of the relevant statutory provision than all the other conditions of entitlement to universal credit, like habitual residence or whatever. You could always turn out to be wrong about are you habitually resident in the UK, for example, a very common line of inquiry. Now, the individual will provide information. The Secretary of State will make a decision as to whether or not you are habitually resident. If he's wrong about, if he makes an award and he's wrong about that, then the machinery is revision or supersession, not to simply say the original decision was not made. And this is working in exactly the same way. It's forcing the provision of information at the start of a claim, or as near as may be to the start of a claim. There's a difficulty about that too. With a statutory provision which doesn't have the potential effect to delay the commencement of payment, let's take your Lordship's point head on, the way in which the machinery actually operates by the Secretary of State, presumably is the best, he would say is the best he can do with it. Well, our grant fee think is a plea that it's not, but assuming that it is for the moment, then treating the requirement that you provide the information required by one large fee be fully verified to the highest level of confidence within the department means that payment of benefit, which is what matters to my clients, payment of benefit does not start for a substantial period after it would otherwise start. And the legislature had a choice. I mean, it could have enacted either the requirement for a national insurance number to be allocated or some other formula which made it pretty clear that entitlement didn't arise until some form of verification had taken place. Didn't do that. Use the form of words. And I still repeat, for the purposes that Mr. Rowland has set out in the second part of paragraph 30. Social Security is full of cases where you basically have trigger conditions. I mean, are you available for employment? Loads and loads of cases in which people have said they're incapable of work but turned out to be fully capable of work. For example, number of children, habitual residence test, and so on. There are cases that the form of words is actually, on ground 2, the form of words actually used in 1B evinces an intent to avoid that sort of logjam. What's more, my next step is the parliamentary material. It's if you like, it's a halfway house. It's a perfectly sensible policy reason for having a provision on the lines of 1B, even if it's not a complete guarantee against fraud. It is, in fact, as we've seen, a guarantee that you will produce enough information for the universal credit agent, as opposed to the NIno agent, to know who you are and all those other matters. So one way of looking at the case is it a case in which the court ought to read into the language of 1B the sort of limitation that your lordship has been putting to it? We say no, it's a perfectly sensible policy reason why you won't have an absolute condition of that sort. The UT, the Upper Tribunal, honed in on the false passport analogy, but as we say, the skeleton, I mean, you could produce a myriad of other examples of false documentation which would lead to a successful claim, unrelated to national insurance numbers. And unsurprisingly, the statute into which 1B is inserted, or the statutory scheme, is actually the 1998 Act, has machinery for dealing with that. Now we say that actually the parliamentary material that does take it much further, actually. I was going to take I'll take your order to it now anyway.
Well, if it doesn't take it much further, we certainly won't get over. That was, speaking myself, the provisional view I'd formed. It doesn't really take it much further.
Well, there were two purposes. One is on the construction of the interim payment one, in which case we say it's pretty well decisive. But on this issue, the ground 2 issue, which is
okay.
Myself.
Is there more to say on round 2?
I don't think there is. I was just running an eye down what I said in the skeleton. I don't think there is. So, I'll probably take round 1 fairly shortly because I've been cheating and slipping in observations about it as I've gone along. But,
okay, round 1.
So, round 1. If your lordships will look at the skeleton, paragraphs 22 to 25. Your Lordship no doubt made from 22 to 25. I repeat them. In fact, Your Lordship draw cast an eye over them again.
Sorry, I was just making a note. Where have we
It's
gone?
page 36 of the core bundle,
Yeah.
and it's paragraphs 22 to 25.
Yeah. Yeah.
And the heart of it is 23.
Yeah. And that's why you say, although if it mattered, you would go for a lower meaning of threat of likely. That's really not the issue here.
No. And that's the purpose of going through what happens in practice, because it's clear that the issue arises very sharply at the point when a claim has gone in which 60% of the cases lead to interim payments then and there. It arises sharply before the form is completed by the universal credit agent and sent off to the NIno agent. And we say it's impossible to say that the likely criteria, whatever its exact shade of meaning, is not satisfied at that point in a very large number of cases.
Suppose you're right about that, then it does require a factual, in principle, it requires a factual determination in each case about the likelihood on the basis of the materials being provided. This is just me thinking aloud. I don't think it's a necessary part of your case. But in fact, in cases where the likelihood largely depends on the genuineness of documents, I suspect is most cases, if a document is provided which isn't an obvious forgery, but will have to be checked against other materials in the usual way, do you have a position about whether the Secretary of State ought in such a case to say, well, look, here are some documents which look all right on their face. Generally, documents are what they purport to be. Therefore, it's likely an award will be made.
Well, I do say that, but I mean, I'm content to rest on this part of the argument on the proposition that at the latest, the time that the universal credit agent fills out Form EC, whatever it is, and says entitlement to benefit has been established, that includes an identity check. It includes it includes looking at the passport.
So the fact stage one has been gone through.
At the very latest, possibly and probably very much earlier. The only view is that it's likely that the condition, that this particular one large B condition of entitlement, is satisfied.
And when we look at the forms, we may see whether anything else has to be provided at that stage by way of information or evidence.
Yes.
Which wasn't considered at the Universal Credit Team stage, but which the NIno people will look at. And I think the answer may be that there isn't anything else.
Well, I mean, I've done my best to do. The material I have is the sequence of events set out in Miss Johnston's witness statement. And frankly, it doesn't look as if much happens beyond what happens at the Universal Credit Agent stage, if I can call it that. I mean, it's obvious to the court. It's an axiom of these sort of claims. If someone is without a NIno, they're highly likely to have just had a, without recourse to public funds, condition lifted. They're likely to have all the documentation that relates to that. It's a relatively easy check to see whether you're habitually resident. That's been done. Now, at that point, it is likely that the one large B condition will be satisfied. But the Secretary of State has taken a stance, in principle, that that's impossible because it contravenes the policy of one large B, as I understand it. And our cases, there's simply nothing in the statutory language to that effect.
Yes. Would you want to try ground 3?
Well, ground 3 is I can deal ground 3 before lunch because it's very, very short.
Yes.
It was important. The assumption behind ground 3 is that we are wrong on the construction of one large B, that we are wrong on the meaning of likely in the advance payment regulations. But nonetheless, the Secretary of State has to justify dealing with the matter in the way in which in the sequence of events in which he does. He goes through, in the guise of the Secretary of State acting through the Universal Credit Team, a verification process. That's a confusing word. I mean, it is a verification process, but I don't mean that. Goes through a process of checking that you are entitled to benefit. And only when that is completed does he then start looking again at the same information in order to see whether a NIno could potentially be allocated. And in the context of the claimants who have no resources, that is an incredibly cumbersome way of doing it.
Just to be clear about this, sorry, I think you've just said it, but I just want to focus on it. This doesn't, if you're wrong on ground 2, but right on ground 1, this doesn't matter because the system that's the safeguard against delay.
Yes, yeah. I mean, that's the legs on ground 3 in a funny sort of way. I mean, we say the safeguard in the system is advance payments. Now, if in fact that's wrong because of the meaning of the word likely in the provision, there is no safeguard, and in that context, the Secretary of State ought to get on with the job and start verifying the NIno material at the outset of the claim, rather than waiting for some considerable time afterwards.
Do we have evidence of how long the 2 stages take? There's evidence that the second stage is meant to take less than 10 working days.
Yes.
How long does the first stage take?
I think there's probably contested territory. Where have we got on there? Yes. We would accept it's within the 5-week period, because not always. I mean, there have been some catastrophic
in these particular cases.
There have been some catastrophic delays, but yes. I mean, it's not part of the reasoning behind ground 3 that you are necessarily pushed beyond the first date of payment, i.e. the 5 weeks. But we know the second stage takes 10 days, and I think we say in the skeleton, our anecdotal impression is often takes very considerably longer than that, quite apart from the sort of administrative failure that took place in these 2 individual cases. But I mean, the point behind ground 3 is that, say, a delay of 3 weeks with no money is a very considerable delay. I can't do better than that. Mr. Brown may have some more material, but
you're about to be given some information from you behind your left shoulder, right shoulder.
Right. Yes. If your lordship, I'm grateful to those as always, but if your lordship would we can do this last step.
So if we do what?
Also, we'll look at the chronology, which is at page 49 of the core bundle. I think. Yep. Now, if you look at just the individual dates in Bui, so that is page 49.
Yeah.
Claim goes in on the 13th of January 2021. Verification of identity 13 days later. So, I mean, just pausing there, I don't think anyone suggested anything went wrong there. So you've got a 13-day gap between the claim on the 13th of January, identity verification on the 26th of January, 13th of February is the habitual residence decision. And the respondent informs claimant that entitlement to UC approved. So if I understand it, there's no suggestion that anything unusual happened in that.
So that is 1 month.
Yes. And then you've got,
If it had happened correctly according to the Secretary of State, you'd then have another up to 10 days
yes,
for stage 2.
and we're slightly sceptical about the 10 days, but
Yes,
yes. I think slightly, very, but yes.
Yes, so if, which anyone's guess, this is typical, you'll be lucky to hit the
You're not beating,
the 1 month or 1 month plus 7 days.
you're not beating the 5 weeks on a well-run scheme. So, whereas obviously if you somehow or other did a bit of verification of the NIno information in parallel with the universal credit checks, you will make a real difference to the timing of the payments.
But that only demonstrates that, I mean, you have to show that it's a wholly irrational scheme because of these features.
Yes.
Well, I shouldn't have put in the word wholly.
Well,
And irrational, right? But that is a very high hurdle.
yes, but we do say that. I mean, you have to look at what information is available to allow the parallel process to take place. I mean, it's enough to verify benefit assessment, assessment or entitlement to benefit. Got that? Axiomatically, you've got enough information to get that far.
And every week that's delayed is a week when the claimant is without income.
Absolutely. So,
Now, well, that's very neat
well, that's
timing.
better than usual.
You may want to locus penitentiae.
Yes, I would
Especially
like
there's some stuff to put in. It's not clear in the end who'll be putting it in, but
No.
with a bit of luck, we'll have
We're
some
going to
further
need to
information.
meet, and I might be told to do 1 or 2 things that I've missed out. I hope not, but if I can reserve my position
Yes, right,
until 2 o'clock.
certainly. Well, we'll say 2 o'clock.
All right.